Hey, y'all, and welcome to tonight's live stream. Last week, we learned about the bombshell allegations from the Murdaugh team that the clerk of court tampered with the Murdaugh jury. This case has become so contentious that now even the jurors have their own lawyers. We're going to talk about that tonight because there's some good news in that for us, which is we're learning some answers to the big question we asked last week. What will the jurors say? I hope you had a great weekend and are back at it this week. We've been covering one of the most dramatic cases I have ever seen in my course as an attorney. The latest in one of many, many twists in this case so far is that the Alec Murdaugh team has filed a request to file a motion for new trial and to have a hearing. Now, that may sound kind of legalese. Essentially, what they're saying is that they believe Alec Murdaugh did not receive a fair trial. They believe that there should be a new trial because they believe that the clerk of court tampered with the jury in his case. As we know, he was convicted of murdering his wife and his son. Those two convictions came after a 6-week trial. And of course, the jury unanimously, all 12, convicted him of that. So what we learned last week from the motion for new trial, which Murdaugh's team attached to their request in the appellate court, they attached the entire brief, and we went over that. Be sure to check those videos out. If you haven't looked at the last two, you are really going to want to see those. What we saw in that attachment was a bunch of attachments to the attachment. That's how lawyers are for you. And there were included in those 2 affidavits from jurors. Those were affidavits where jurors said, I believe this, this, and this. They signed it at the bottom. It was their statement, their affidavit or statement of truth. And those 2 jurors made some very serious allegations about what the clerk did and how she interacted with the jury. There were also 2 other affidavits attached, but those were not affidavits of the jurors. They were affidavits by a paralegal about her conversation and the attorney's conversations with the jurors. Because what happened was that Alec Murdaugh's team, apparently a couple of attorneys and a paralegal, all went out and talked to the people, to the jurors, or at least as many as they could get to talk to them. Apparently, 2 of the jurors either were not able to be contacted to sign the affidavit, or they refused to sign the affidavit. And so instead, Murdaugh's team filled out an affidavit themselves, and the paralegal signed it saying, this is what they told me. Now, that's much more difficult to get in evidence because it's not a statement by the juror. So those are not as strong. And that raised the really important question, what are the other jurors going to say? Are other jurors going to support the Murdaugh team's statement that the clerk interfered with the jury, that she tampered with the jury, that she contacted the jury inappropriately or made statements to them? So what we're trying to do is figure that out. What will they say? The Murdaugh team also says that the clerk actually went on a vendetta to get one particular juror off the jury, and that the reason she did all of this was because she wanted the fame and fortune of a book, which she in fact did publish a book. And they're saying that was the reason that she went to all this trouble and that she made such an effort to make sure that the jurors would convict Alec Murdaugh. She didn't believe she would make as much money or write as impressive a book if he were not convicted. So there was a very significant interview by CourtTV of 2 of the attorneys who represent Murdaugh jurors. They have different viewpoints, and they explain, I think, very well the issues we're going to see play out. The first attorney is Joe McCullough. He represents the 2 jurors who gave sworn affidavits that were attached to the Murdaugh motion for new trial. And he also was on the Fox Nation documentary that we covered about a week ago. He was, I would say, relatively pro-Murdaugh in this one sense, not necessarily in terms of guilt or innocence, but in terms of he seemed to believe that there had been evidence admitted at trial that should not have been admitted. And he represents apparently the two witnesses who signed the affidavits attached to Murdaugh's motion. The other attorney, Eric Bland, also represents, according to what he said, two jurors, and he represents the Satterfields in a case against Alec Murdaugh. Now, this was one of the cases where Alec Murdaugh has admitted to financial improprieties. He admitted that he stole money from the Satterfield boys. And then, in a weird twist, one of the many, like I say, Alec he initially got millions of dollars for them. Well, more precisely, he said that their mother, who was his housekeeper / nanny, that she tripped over his dogs, fell down his stairs, and that she was injured. And the Satterfields then sued Alec Murdaugh's insurance company at his request. They were technically suing Alec Murdaugh, so he got someone else to represent them. But according to what he admitted, he stole the money that was supposed to go to the Murdaughs. Both he and the other attorney, the other attorney has pled guilty and will be going to jail, the one who's actually representing the Satterfields. So Eric Bland took the Satterfields case against Alec Murdaugh and against the attorney who represented them. Then Alec tried, I'm sorry to be going into too much detail, give me 20 more seconds and we'll get back to the topic. Alec tried to retract his statement that Gloria Satterfield had tripped over his dogs and fallen down the stairs. Eric Bland then called him liar, liar, Alex. I think it was in a tweet. So I say all this to give you an insight into Eric Bland. He's not pro-Murdaugh, very much not pro-Murdaugh. He would, if anything, be on the opposite side of Murdaugh in at least one case. So I'm just going to show you a couple of clips from the CourtTV. It's definitely worth a view, and I've already put the link in the description. So after this, go watch their full-length interview of these two attorneys. It's real interesting, but I just wanted to make a couple of points, actually 3 points here. And so I do want to say, too, we are going to be covering this in more detail. I read this weekend the entire book by the clerk, Becky Hill, and I have I need some more time to prepare what I want to say to you about that. But I found some very disturbing things in the book that I think are important. And I'm going to bring those to you probably Wednesday. You definitely want to hit subscribe because you want to hear about that. This is some really important information, I think. I'm also going to be looking specifically at ethics rules that might apply to court officials and see, because I want to, like you, dissect this, figure it out, understand it. So for tonight, I'm going to cover 3 topics. One, let me finish my thought there. Please be sure to subscribe. We would love to have you back, and we have some great, really interesting content coming up that I think you'd like to see. Also, if you would hit the like button, it would help the video get out to more people, and I would appreciate it. So we're going to look at 3 things tonight. What the other jurors will say, and we got some clues from Eric Bland and what he said. Secondly, lawyers, I want you to see how the lawyers, Joe McCullough and Eric Bland, how they differ, how they have different opinions about what the standard should be for how the court will decide Murdaugh's motion for new trial, if he's allowed to file it and if there's a hearing. And then I want to answer the third question, which is all this lawyering up by the jurors, is that even necessary? Is it overkill? Let's talk about that. So now the first topic, what the other jurors will say. We know what the jurors will say who filed their own affidavits. Although I will say in cross-examination, there can be a lot of play in something like an affidavit. And that's who Joe McCullough represents. So now we're going to talk about what about the other jurors. And let me be clear, too, on the 2 jurors that Joe McCullough represents, only one of them was actually a juror. I mean, I'm assuming he said the 2 who filed affidavits. One of the ones who filed an affidavit was going to be on the jury, and the judge removed her on the day of deliberations. And so she actually was not a juror, which means there are 11 where we don't know what their opinion is going to be. We don't know what they will say about whether or not the clerk interacted with the jury in an inappropriate way, whether she spent a lot of time with particular jurors. We don't know what they're going to say. So Vinnie Politan asked the Eric Bland, what about your jurors? What are they going to say, the ones that you represent? And let's see what he has to say.
attorney-client privilege. I represent 2 jurors, but I am pretty sure
So
I can't reveal
it's-
attorney-client privilege. I represent 2 jurors, but I am pretty sure that what you're going to hear from some of the jurors, if not most of the jurors, except the ones that Joe is representing, it is directly the opposite of what Dick Harpootlian said from the microphone on Tuesday. You know, Vinny, no matter how many times you say something or how loud you say something, doesn't make it true if it's not true. And the fact that there are 1 or 2 jurors that say Ms. Hill said some things before Alex testified or allegedly made some comments about the defense attorneys is troubling. No question it should be investigated. We can never have a situation where anybody other than the judge gives instructions to the jury. But don't be fooled here. You know, these are jurors that sat for 7 weeks and listened to the evidence. If an innocuous statement was made or some kind of offhanded comment, I am certain that 12 jurors would not have given somebody a conviction of murder and ultimately a life sentence simply because of one thing that was said when they heard evidence for 7 weeks and they saw people testify. But again, this is very serious.
So we know that from what he's saying, that his 2 jurors will say something different. Now, we don't know anything specific about that. We just can gather from what he said that the 2 jurors are going to say that are not going to agree that Becky Hill interfered with the jury. That's what we can assume from what he's saying. But we don't know whether they will say, yes, there were private conversations between the jury foreman and Becky Hill, or whether some of these particular statements that were alleged in the other 2 jurors' affidavits were in fact said. So we'll have to wait to see that. I do want to make one comment. I was overall very impressed. I can imagine, Eric Bland has every reason to be biased, having represented the Satterfields against Murdaugh, but he acknowledges the seriousness of the accusations and wants it investigated. And I think that speaks to his credibility there. The key, I think, and this is separate and apart from this, is that it has to be investigated by someone who is perceived as unbiased. I put that on Twitter. Be sure to follow me over there at Lawyer Lee W. And in my view, that's not SLED. That's not to say anything negative about SLED, South Carolina Law Enforcement Division. I don't have any opinion about whether they were. I don't have any opinion that they were incompetent or did anything bad. It's simply that I don't think the Murdaugh camp can ever believe that they were not biased. I think in order to truly lay this to rest, the investigation needs to be by someone unbiased, someone neutral. So, and the second thing I want to talk about tonight is the clear differences on the standard. Now, Eric Bland is going to argue we can't look into a jury verdict after the fact. And I'm going to give you a war story on that afterwards, after I play his part here. Let's go ahead and play that.
We can't have a system where jurors make a decision, render a verdict, are individually polled, swore to uphold the law, in open court say that they gave a free and just verdict without coercion or duress, and then 3 months later, whether they decide they're going to change their mind or they have a decision remorse or they're manipulated a little bit by the defense attorneys when they're confronted. I worry about a system if we can open up the can after every major jury verdict, if 1 or 2 jurors decide to create a disturbance that has been created here, and we'll see. You know, we'll see where it goes. But if 10 jurors say it didn't happen and 2 say it does, I think a judge is going to have to ultimately rule in favor of the prosecution.
So I do want to say that what he says about this, about it being important not to undermine a jury, not to open up the idea that every time a jury could go back and say, you know, we've changed our minds, and then you would have to retry the case, because that would undermine the entire system. And I'll tell you that way back when I was on a trial team, we tried a case, $104 million was the verdict on that. About, I believe, 101 million or 100 point something was for punitive damages. under the law of my state, it had to be supported by an award for pain and suffering. The jury gave an award of $1 for pain and suffering. It was in a horrific death case. And then the question was, okay, what does that mean? If they only gave $1 for pain and suffering, does that mean they really didn't believe there was pain and suffering? They just wanted to give punitive damages, in which case they wouldn't be allowed to do that. So we went and got affidavits from the jurors in the case. Now, there's nothing wrong with doing that. If the jurors will talk to you, you're allowed to do that. But the court did not want to accept the affidavits because the court didn't want to go behind the verdict. It was $1. That's what it was. And we had to figure out what that meant legally without statements or information from the juror. So Eric Blands is using the standard, or talking as if he would be using the standard, about would it make a difference? Would it make a difference if the jury was talking to the clerk and she said these various things? Did the jury actually listen to that and follow her and only decide what it decided because she influenced them? Or were they thinking on their own? Would they have reached this conclusion anyway? That's a really important difference. And I want you to hear now what it is that the Murdaugh team says as it's expressed by McCullough.
Our responsibility is to protect the process, not the result. As lawyers, whether you agree with the guilty verdict or not, the question before us now, before the court, the fascination that is creating the need for us to be on television, it's about what happened.
So what Joe McCullough is saying is, this isn't a question of whether or not the jury was changed, or the jury's mind was changed, or the jury reached this decision because of what Becky Hill said to them. This is a question of process. Under no circumstances can a clerk of court take her opinion to the jury and try to persuade them. That would be wildly improper. So he's saying that happening alone, a court official going to the jury to persuade them or to say things that might bias them, must be stopped. It doesn't matter whether it made a difference in this one case. It's so important that it can't be allowed to happen. And that's what the Murdaugh team says as well. They say it shouldn't matter whether it made a difference. And furthermore, they even had an entire paragraph in the brief that they filed quoting what the judge said at the time of sentencing. He said, or it may have been just right after the verdict, but he said all of the evidence supports this. All of the evidence supports Alec Murdaugh being guilty. They're saying someone who believes that all of the evidence supports it, obviously could never find that it changed the verdict because all of the evidence supported it. But that's not the standard. That's what the Murdaugh team is saying. I do want to make a note. He goes on to in the course of the interview, they talk about Becky Hill's job as a clerk. And I do agree that she did a remarkable job as a clerk. That is a very, it's a logistical nightmare. I mean, I can't even imagine what it must have been like to coordinate all of those people, all of those things from media. And she describes that in her book. She goes through what it is she did. I do want you to ask yourself this, though. Do you have any idea who the clerk of court was in the Johnny Depp versus Amber Heard trial? And I think your answer is going to be no. You have no idea. You probably watched that trial or parts of it, and you have no idea who the clerk was. They didn't write a book. They did the same job. It was just as hard for them, I assure you. But it is a very uncommon scope of this job for either Becky Hill or whoever the clerk was in the Johnny Depp versus Amber Heard case. That was an extremely difficult job, and she does deserve credit for that. Now, I want to talk just for a second about her book. I'm going to do a bigger segment on this. Well, I'll cover her book in greater detail, but her book is not just about her job. It also includes her opinions about the case and about people, from jurors to the defendant. She calls Alec Murdaugh a narcissist, for example. So we will talk about that. There are some what I think are troubling parts in it. We'll talk about whether that will be a problem for her, whether that will help or support the motion for a new trial or not. Now, I do want to mention one unusual thing that McCullough stated in this interview.
I'm not happy to be in the position I am representing two jurors. I was asked by the jurors originally to keep the press away from them. Things happened. I can't go into those things, but their decision to give information under oath now is a part of a record that will have to be evaluated. But they came forward reluctantly. They provided their truth. And now that becomes a part of a record that must be evaluated by the court. I mean, it's the troll patrol that's out there feverishly protecting a verdict cannot be joined by lawyers. It's not our job, Eric. Our job is to protect the process.
There were two things I found absolutely fascinating about that. One was it was as if he was in the middle of an argument with Eric. Like the two of them had been discussing this right before they got out here, and they just came out and he's still talking to Eric, because that didn't show up in the interview. Go back and watch it yourself. Go watch the CourtTV interview and you'll see what I mean. So it's as if he's trying to persuade Eric, but it just kind of came out of nowhere. The other thing that really intrigued me about that is his statement that he wasn't happy to be in this position and the jurors wanted him to keep the press away from them, and things happened and he can't go into those things. That was really interesting. It made me wonder whether or not it was perhaps against the jurors' wishes that this press conference be held. I was just curious about that. I didn't know what things happened meant. Did the Murdaugh team force his hand? Did he feel like that? I wondered about that. Now, on the third category that I want to talk about whether all this lawyering up by the jurors is really necessary. Now, Vinnie Politan asked the CourtTV reporter, about the fact that jurors seem to feel, at least 4 of them, that they need an attorney. I will say I've never heard of that before. Maybe if one juror were accused of something really specific, like taking a bribe or something, maybe that juror would need an attorney. But I've never heard where across the board a number of jurors suddenly go out and get attorneys. That is really unheard of. So, and what I thought this comment, I'll play it for you. I did agree.
So far as I know, is in some kind of jeopardy unless they do not tell the truth when they are asked to do so.
And I think that's right. I can't imagine that the jurors are in substantial trouble. The only problem I can see for them is perhaps that they talked about the case amongst themselves, from what several of the jurors said before they actually went into deliberations. It's already out of the bag. They all agree. In practical terms, I would be very surprised if any kind of action were taken against them about that. In practical terms, I would be very surprised. So now there were a couple of comments that were made. I did want to discuss. It's
kind of unfair that Dick got the microphone. I have some questions about the propriety of just even doing the press conference without the AG filing anything.
Now, from other comments that I made, if you've been following the channel, that I disagree with that. I believe that lawyers are missing the boat and ignoring the fact that social media has taken over and is very much a part of the justice system now. And attorneys are still in the old school where they think this all needs to be confidential, it all needs to be private, and it will be tried solely and entirely in the 4 walls of the courtroom. And I don't think that's realistic. I think that the defense in this case and in many others made the mistake about not being more public in the past. I think lawyers are losing for their clients in high profile cases because they aren't taking their points to the public and they're letting the prosecution go first and then they never really respond. It's already too late.
Wasn't in response to anything, but it is what it is. But I did take umbrage with him threatening Judge Newman that he was going to be a witness and wouldn't be able to hear this if it was remanded back once his motion to stay the appeal is heard. But there's a couple things. And again, these are important allegations.
So first of all, I want to say again that I really do appreciate that he takes these allegations very seriously. I think that's impressive, especially given that he doesn't necessarily have a reason to do that. He might have the reason to do the opposite. I do have to agree with him too that maybe Harpootlian could have taken a slightly different route in talking about Judge Newman potentially being a witness. I think this speaks to the desperation that the Murdaugh side feels. I think that they believe that the entire system worldwide is stacked against them. that the media, the podcasts, the courts, now the clerk of court, everything is stacked against them, and their only hope is to go to the public. I really do think that's why they are taking this course. I think they thought, if we just file something and don't have a press conference, nobody will pay attention. And they said, we've got to make this big. We've got, in order to protect our client, this is what we need to do. And then final point.
Preferred that she would have waited until the appeal was over. You never know with these cases. Obviously, the 404B character evidence was a hotly contested issue, which is going to be up on appeal, and there.
So, and let me give you a little context that kind of popped us in the middle of this, but essentially, he's talking about Becky Hill's book, and he's saying, I would really have preferred if she would have waited, instead of until the appeal was over, not file it right away. He says the same thing about Judge Newman. Well, I'll go ahead and let you listen.
Is a possibility that it could be reversed. And so I would have preferred that the court officials would have waited to, write a book. I'm certainly going to be waiting to hear what happens with Judge Newman if there's a retrial. Was his interview that he gave to the Today Show something that could disqualify him? So
that I fully agree with. I'm going to go ahead and pull that out now. I fully agree with that. It would be, I think, very difficult for Becky Hill to be the clerk of court, to perform her role as clerk of court, if the case ended up being remanded for a new trial, or if it even was reversed on appeal. It would have been very difficult for her. She's written a book in which she called the defendant a narcissist, when she said over and over that he was guilty, she knew he was guilty, and that she knew it fairly early on. She's also said numerous things about the Murdaugh family and about other members of the Murdaugh family. Any of that, I think, would make it very difficult for there to be the appearance that she would be fair the second time around. It doesn't mean that she wouldn't be. It's all a question of what would people perceive? Would they perceive her as being fair? And I think that Eric Bland is raising an excellent point. That's also going to be a question with Judge Newman based on his Today Show interview, and that'll have to just be hashed out. People will have to make those arguments and see what happens. But I agree with him. It would have been better to have held off on any kind of interviews or any kind of books until the appeal process was over. It just would have been safer. So now, don't forget about Wednesday. It's going to be very important, very significant live for us. I'm going to be talking about the book that Becky Hill wrote. I'm going to be talking about the ethics rules that might apply, whether or not they might apply. And may I say, these are national proposed rules, not really proposed, they're recommended rules, but they are not ones that directly govern Becky Hill. So we're going to go through how does this fit? What do we think about that based on what the suggested recommended rules or ethics procedures would be. So be sure to hit that subscribe button, because you don't want to miss that. And if you would, hit the like button on your way out, and I will see you on Wednesday at 7 o'clock.